Okay, wonderful. So I hope everyone can hear me. It's a fairly small, intimate space, so maybe it's better not to have a microphone. Thank you very much to Northern Justice Watch for inviting me here, and thank you to all of you for coming on your Sunday, on your summer weekend, to listen about some pretty intense and serious issues, but it means that you're all very committed and interested to these topics, and I really hope that today's seminar will be interesting for you, will be useful for you, and that hopefully can lead to some productive outcomes down the line around justice and accountability for human rights abuses. So maybe, I appreciate the introduction. I thought I would explain a little bit more about my background, but also because we're a smaller space here, maybe I would also like to ask some of you some questions just to get a better sense of who's in the room and what type of interests you have around the topic for today. So as was explained, I am a lawyer. I'm a Canadian lawyer, but the focus of my work for over a decade now has been on international human rights, which is a very broad umbrella, but also more specifically within international human rights, international crimes. And international crimes are very specific. It's a very specific part of human rights abuses, and these include genocide, crimes against humanity, war crimes, and now also aggression. And I used to be the legal director of a small NGO based in Ottawa for many years called the Canadian Centre for International Justice. And the work that I did as a lawyer there was to help victims and victim communities who are looking to seek redress and accountability for human rights abuses to find legal pathways and legal avenues to help them seek accountability. So the work that we did included things like what Northern Justice Watch is doing today, a lot of education and awareness, but we also brought legal cases, whether it was to international bodies or whether it was to the United Nations human rights system and framework. And so the goal of today's session and what I'm going to speak to you about is, as you can see, international accountability mechanisms. And I won't be able to focus on all of the international accountability mechanisms that exist, but I'll try to focus on a few key ones and explain the differences and the similarities between these different avenues, and hopefully it'll help you better navigate and understand some of the different options that are available to you, and what those options can give in terms of remedies for victims, and what forms of participation by victims are actually allowed under those processes. So before I start, I'd like maybe to ask a few questions of the audience, and maybe you can just raise your hand if it is applicable to you, just to get a better sense of who you are. So I guess my first question is, I'm curious, how many lawyers are in the room, or people with a legal background? Okay, so we've got a few. Nice to see. Great. And how many are you are human rights activists or human rights defenders and have been working on human rights in different areas? Okay, so we have a few in the room. How many of you would call yourselves victims or survivors of human rights abuses in different contexts from where you come from, or even here in Canada? Okay, quite a few of you. Okay. How many of you know about international accountability mechanisms or have ever used an international accountability mechanism to address some of the issues that you've dealt with? Okay. So I'm going to be coming back to some of you and asking you about that. And how many of you know a lot or a little about the UN human rights system more broadly, or have used any of the procedures or mechanisms through the United Nations to address some of the human rights issues that you've dealt with? So. Okay. Okay, that's helpful for me to know. So I'm going to dive in, and I'm going to be talking about international accountability mechanisms. And so maybe the first question I'd like to ask the audience is, what do we mean when we say international accountability mechanism? What does that mean to you? You've chosen to come here for this seminar. Do you have a sense of what we're going to be talking about? I might put some of the lawyers on the spot. Yes.
For the international accountability, the thing is, I'm from Turkey, so I only know the international accountability mechanism of the Europe, but I don't have any idea in Turkey that it could be addressed directly to UN or other international organizations. The only focus in Turkey is the European Court of Justice or European higher level of the jurisdictions.
Yes. So you brought up a good example of one type of accountability mechanism, which is the European Court, right? So I'm going to take a step back because I want us to really understand what it is that we're talking about today. So here you can see I've put international accountability mechanisms are forums or processes or procedures that ensure that either states or entities like groups or corporations or individuals are held responsible for their actions, right? Someone does something that they shouldn't do, and they should be held responsible for doing that. And there's a difference between national accountability mechanisms and international. In a country like Canada, there are domestic processes, we have courts, we have tribunals, we have different ways in which we can hold people accountable here for things that happen in this country. But when we talk about international accountability mechanisms, these tend to be forums and processes that are meant to address the issues that domestic or national jurisdictions don't deal with or don't want to deal with. So what you'll see is that a lot of times what we have in the international space, it's meant to fill a gap in what is possible or not possible to do domestically. So in your example of Turkey, there are some potential accountability mechanisms within the Turkish legal system, but certainly if the state is committing human rights abuses, there are probably a lot of things that the state itself will not actually address in its own national system, which is why many victims feel like they need to go and seek accountability through an international forum, because in their domestic context, they don't have access to justice. So that's what we're going to talk about today. And there are a lot of different types of international accountability mechanisms. And I'll be talking about 3 general types, and I'll be explaining these mechanisms and how they are used, who's able to use them, and under what circumstances, and the role that victims and victim communities potentially have. One of them is going to be the International Court of Justice. Does anybody know or have experience with the International Court of Justice? Has anybody heard about the International Court of Justice in the media lately because of certain high-profile cases? Yes. Are there any cases that anyone knows about or has been reading about recently? Okay, so I'll give a few examples later. I've put a few examples here. So this is a court of law. So this is a legal court of law where states can bring cases against other states for violations of international law. And I'll explain that in a moment, but some key examples that are going to be interesting for you. So the Gambia brought a case against Myanmar under the Genocide Convention. So this is a case looking specifically at a state committing genocide brought by another state to hold them accountable. We also have Canada and the Netherlands brought a case against Syria under the Convention Against Torture. So this is Canada and the Netherlands bringing Syria to court for Syria's systemic use of torture in the country. We also have a recent very high-profile case where South Africa brought Israel to court under the Genocide Convention as well for what's happening in Gaza. And we also have high-profile cases between Ukraine and Russia, again, under the Genocide Convention and a few other treaties. So this is one of the international mechanisms that I will be discussing in detail a little bit down the line. I'm going to give you an overview of the other 2, and then we'll go back and get into some details. The second international accountability mechanism that I'd like to address today and explain a little bit about is the International Criminal Court. So does anybody here have any knowledge or experience with the International Criminal Court or know what it is? I see some nodding, yes? What do you know about the court?
I hear, but
Okay. Anybody else? We have a few lawyers. I'm going to put you on the spot. Does anybody have any experience or knowledge about the court? Okay, so a lot of times in the media, there's actually a lot of confusion between the International Court of Justice and the International Criminal Court. So what I'm hoping we'll get to do today is really explain the differences between these 2 courts so that you'll never confuse the 2 courts ever again. Because it's something that happens even with people who work in this space, journalists who write about all of these things. The International Court of Justice, as I mentioned, is a court where states can bring other states for violations of international law and international treaties. The International Criminal Court is also a court of law, but it's a court of law that is a criminal court, and it's a criminal process against individuals. And so a prosecutor will bring a case against an individual who has committed one of the crimes under the jurisdiction of the court, and they will then try to prosecute them. And if they're successful, then there will be a conviction and that person will go to jail. So this is a criminal court, it's not a civil court. And so there are some very high profile cases, and we'll talk about a few examples a little bit later with the International Criminal Court. There's a case, an ongoing case right now against Omar al-Bashir of Sudan. They've been trying to arrest him for a very long time, and he has not been arrested, but there is a warrant for his arrest out. There is also a very high-profile case against Rodrigo Duterte from the Philippines. He was just recently actually arrested and brought to The Hague, and so the case against him is proceeding. There is also a case against Vladimir Putin of Russia. He has not been arrested, but there is a warrant for his arrest. And there is also now very high-profile cases against Benjamin Netanyahu of Israel and his former Minister of Defense, again, for what's been happening in Gaza. So as you can see, the very clear difference between the two is that it's not a case against a state or a government, it's a case against an individual for their individual role in committing either genocide, war crimes, crimes against humanity, or aggression, which are the international crimes that this court deals with. So we'll talk about that in a little bit as well. And then finally, the last kind of pillar of mechanisms that I'll talk about, and there's many mechanisms within this umbrella, but it's the United Nations human rights system. So the United Nations does a lot of work in terms of how to regulate and manage many different countries around the world on many different issues. And part of that work also includes human rights and making sure that countries fulfill their international obligations to respect human rights and not to commit human rights. And so there are a few mechanisms within the UN human rights system that allow for states to monitor each other, for states to bring not cases necessarily, but to investigate each other and make sure that there's a respect for international law and international norms. And there are some processes as well where victims can participate and can bring information to the United Nations, to experts, to committees, to make sure that countries are also being held accountable. And so some of those examples that we'll talk about today are the UN Human Rights Council, which includes special procedures, the Universal Periodic Review, and UN investigative bodies, and we'll talk about each of those in a moment. And then there's also the UN treaty bodies. So there are some core human rights treaties that a lot of countries have signed and they've ratified. And when a country signs and ratifies a treaty, they are saying, we agree to respect what these obligations are in this treaty, and we commit ourselves to not to do the things that are prohibited and to make sure that we are respecting our obligations. And if they sign a treaty, they have voluntarily committed to respecting those rules. And so there are committees that are set up within the United Nations to monitor whether countries are actually respecting those rules or not. And those are some processes by which victims can also try to hold countries accountable for not respecting those laws. So these are the different topics that we'll be talking about today. It doesn't address every type of international mechanism. It doesn't address domestic mechanisms, including some domestic mechanisms available here in Canada, but I do believe that there will be many, many more seminars, and I'm sure that those issues will be addressed down the line. But I hope that it'll be an interesting overview for those of you who are less familiar with these topics, to just at least be able to navigate and understand what are these different systems and what are the differences between them, and potentially what are some strategic opportunities for you, whether you're a victim of human rights abuses, whether you work for a community or with a community that has been victimized, of how you might be able to use some of these processes to bring the issues that matter to you to some type of adjudicator or someone who is an expert, someone who can actually help in terms of accountability and justice. So are there any questions so far about what I've explained? Am I going too fast or too slow? Is it okay? All right, great. Okay, perfect. So what I'll do is I'm going to start off by talking a little bit more in depth about the International Court of Justice, and then we'll take a little break and you guys can sit with that for a little bit, and then we'll go and talk about the other two mechanisms. So I'll get started with the International Court of Justice. So The first thing is, what kind of court is it? So I did talk about this a little bit at the beginning, but I think it's really, really important to know that different courts and different mechanisms are set up for different purposes. They're not all going to address the same issues, and international law historically has really been a state-to-state environment. So states and governments of states set up a system to regulate themselves, right? It's a voluntary system that states have committed to engage in, and states are negotiating treaties with other states. So they're creating the rules that they want to then abide by. So it's a very state-centric system that we've had historically, which means that individual people, especially people who come from countries where their governments don't necessarily have their best interest at heart, or their governments are not necessarily protecting them, they don't have much of a say in the international legal framework. That has changed a little bit over the years, and there are more and more opportunities for individuals or for nonprofits like Northern Justice Watch or other groups who want to work on behalf of communities and with communities. There's more room now for those types of groups to engage in international law and international human rights systems, but the framework that we have was historically meant to be states for states and states against states. And so the International Court of Justice is a really good example of a forum that actually is set up for states, by states, and it's meant to allow states to bring cases against other states when they feel that they have been wronged by another state. So it is not a criminal system, it's a civil system. And I'll explain, I have a few examples, so I'll explain a little bit how that works, but basically, there are many different treaties that states have signed, either multilateral treaties, so treaties are conventions or international agreements that states sign up to, and it could be many states sign up to a treaty together. So for example, the Genocide Convention, there were many states that came together and said genocide is so awful that we all commit and we all sign up to the Genocide Convention to prevent and to punish genocide. This is a multilateral treaty with many states. But there are also bilateral treaties. So countries like Canada might get into an agreement with another country like Belgium, and they have an agreement with each other. If one of those countries doesn't respect that agreement, sometimes in those treaties, they can come to the International Court of Justice to resolve those disputes. So it's a resolution of dispute mechanism really for states. Any questions about that? Okay. So what does that mean? If it's a state-for-state mechanism, who can bring a case at the International Court of Justice? Can someone answer that for me? Well, like I said, it's not a criminal court, right? So if it's a state-to-state court, who is the plaintiff? Who is the defendant? Who can bring a case? We were a very shy audience. I hope that by the end of today, I'll get everyone to at least say something, because it's a lot to talk for 3 hours by myself. I really hope you'll want to help me out a bit. Maybe one of the lawyers in the room can tell me.
It is private, so that means anyone can raise these files and then submit these files and then process it.
No, no.
It is only guessing.
It's okay, I'm glad you guessed, and there's no bad answer, but it's good because it helps everyone understand, no, not anybody could bring a case, actually, and there's no prosecutor because it's not a criminal court. So who can bring a case here? Exactly, yes. Did you want to add?
I was going to say state as well.
A state. So if I'm telling you that this court is for states to bring cases against other states, that means the only people that can actually start formally initiate a case here is the government of a country. So that means that for victims who have been, have had their human rights violated, or who have been victims of international crimes, this is not necessarily the most obvious or the most appropriate forum for them, because it's really, really limited to states bringing cases against other states. It doesn't mean that human rights cannot be addressed in this forum, and I'm going to give you examples of human rights cases that are there, but it means that there needs to be a state that is willing, that is interested, that has received, for example, information and advocacy on behalf of communities and is willing to then take a case on behalf of those issues. And it's not always obvious whether states are willing to do that or able to do that. So we know that states can bring cases against other states, but on what basis can they bring a case? So I explained a little bit, I gave a few hints, but under what conditions can they bring a case against another state? Yes.
Did you say war crimes?
Why war crimes?
For example, like they're attacking certain individuals, like minorities into the state?
I think you're getting there, but I want us to take a step back and not be so specific about the potential human rights abuse, but to really think about if states are involved in international law and they sign treaties and conventions with each other, and they believe that someone is not respecting their obligations under a treaty or convention, so they want to bring a case against them. So they're able to bring a case based on specific conventions, specific treaties that a country has actually signed, that they have an obligation to respect, and that a country believes they are not respecting. So it means that not every topic is potentially available. You have to look at specific laws, specific international laws, and specific treaties. And the thing that's a bit complicated here is that not all states will sign all treaties. And sometimes if a state signs a treaty, they might not sign it when the treaty first was written or first became law. They might sign it 10 years later, 20 years later, 30 years later. So there's also a time frame question in terms of how far back can we go, or when did these obligations actually become obligations? So it gets very complicated, and I don't want to get into the details of that, but what I think is important is just to know that it's very case by case specific, and it's important to understand if you, for example, you brought up the example of Turkey, right? It's important for you to know what are the international treaties that Turkey has signed, and when did they sign them? Because based on what Turkey has committed to and the treaties that they have voluntarily said, I will respect these laws or I will respect these rights, then based on those, there may be opportunities to hold them accountable if they are not respecting those. But if they haven't signed a treaty or if they have not committed to some of these human rights conventions, then it makes it very, very difficult to hold them accountable, and especially to hold them accountable in a forum like the International Court of Justice. Does that make sense to everybody? Is that clear? Okay, great.
I have a quick question.
Yes.
So, if a country is not a signatory to this, can another country bring the
No. No, and that's why we have a lot of accountability gaps, because a lot of countries, so for example, may I ask, is there a particular country that's interesting for you?
Yeah, absolutely. I'm from Ethiopia.
Okay.
Tigray is where I come from.
Okay. So as a good example, there are certain human rights conventions that Ethiopia perhaps has not signed or has not agreed to. And there are some countries who have really just not signed anything, right? And so unfortunately, because this is a system set up for states and it's a consent-based system, it means that states voluntarily commit themselves. There's no way to force a state to commit themselves to something, so then it becomes really hard to hold a state accountable if they have not actually signed a treaty. But there are other ways, and we'll talk about that, but when it comes to the International Court of Justice specifically, it's a forum that may not be available. And the other thing to also keep in mind is that not all treaties offer the International Court of Justice as the forum for a dispute resolution mechanism. Sometimes treaties will suggest a different forum, or they will suggest arbitration, which is a different legal process. So you also have to look at the specific treaty that's relevant for you and see whether the International Court of Justice is the actual applicable forum. And if it is, then sometimes there is an opportunity to bring a state to bring another state to the court. But it becomes very specific and very tricky. So what I thought I would do is just explain a few conventions that are human rights related that countries have signed and that are bases by which like a state could be brought to the court. So there's the Genocide Convention, and the Genocide Convention was a convention that originated back in 1948. Many countries have signed on to it, but also genocide has also become one of those crimes that is so egregious, that has so much customary international law around it, that even if countries have not signed the Genocide Convention, it is considered a customary norm that countries should not be committing genocide. But the Genocide Convention offers the International Court of Justice as the forum for a dispute resolution. There's also the Convention Against Torture, which a lot of countries have signed, some of them have not. And there's also the Convention on the Elimination of Discrimination Against Women, which I'll bring up in a moment with an example that we have with the court. So these are just some examples, but there are hundreds, if not thousands, of treaties. And so it's really important, again, to understand what treaty or what international rules are being violated and to see whether the International Court of Justice is actually an applicable avenue. So then the natural question would be, then what is the role of victims here? And I think it's pretty obvious that it's a very limited role. Victims do not have a formal role at the court, so a victim can't bring a case against a state. A victim doesn't have standing as a participant in these types of proceedings. However, it doesn't mean that victims have no role whatsoever. And actually, when you'll see some of the examples that I share, victims who have advocated for some of the really egregious human rights abuses that have happened to them, such as genocide or torture, victim communities have really lobbied and have advocated with governments to say, hey, this matters. You have, for example, in Canada, we have a huge community of people that live here that are Canadian, and this is something that matters to us. And they can actually influence governments to potentially bring a case against another state on behalf of these human rights abuses that all states should have an interest in eradicating, in preventing, and in punishing. But again, the role is fairly limited. It's not a very obvious or a very, it's not a very easy pathway for a victim to be able to bring a case when it comes to the International Court of Justice. And finally, what's important to think about also when you're thinking about international accountability mechanisms is what are the remedies that are available? And when I say remedy, it means if someone has wronged you, if you believe your rights have been abused, what can be done about it? And each international accountability mechanism will have its own set of procedures, it'll have its own rules, but it will also have its own set of the types of remedies that it can offer to either a victim, to a defendant or a plaintiff, or to any party that is going to be going before it. And so the International Court of Justice is also its own court, and it has specific types of remedies that it can provide. So if a state brings a case against another state at the International Court of Justice, and they believe that their rights have been violated under a specific convention, the court can give a few different orders or remedies. So one of them is provisional measures. Provisional measures are measures that are meant to be temporary and urgent. So if you bring a case, sometimes it takes years before the case is fully realized and the court makes a final judgment. But sometimes if it's a human rights concern, if genocide is ongoing and it's happening, or if crimes, if these certain human rights abuses like torture are ongoing and people are being harmed, you can ask the court for a provisional measure to try to stop some of those human rights abuses until the court makes a final judgment. And so there's examples of this where you've had cases where people are saying, look, people are dying. Can you order that this country should not do these things or carry out these actions so that these people don't have the risk of dying until the court can actually make a final determination on a case? So that's what a provisional measure is. There's also specific action that the court can order at the end of a case. So if a country is doing something unlawful, they can order the country to stop doing what is unlawful. Or they can order a country to fulfill certain positive obligations that they need to fulfill under a treaty. They can also order restitution. So if something was harmed, if something was done, they can try to, they can order a country to do what they need to do to bring the country who was harmed back to a position that they would have been in if they hadn't been harmed. This is something that is interesting in some of the cases. For example, there was the downing of the Ukrainian Airlines flight in Tehran. And so actually Canada brought a case against Iran with regards to that flight. So again, this is a state. This is Canada bringing a case with a few other countries against another state for what has happened to them. And so restitution can look like compensation, so money for the victims or for the people that were harmed, or for the country itself that has certain interests or had to expend a certain amount of money to support victims in their countries. So the court can also order some of these types of compensation. And then one that's really interesting is the promise of non-repetition. So promising not to do that again. You know, if you're committing genocide and you shouldn't be committing genocide, in addition to all these other things that the country should do to stop committing genocide, there should be a promise not to repeat that again, to never do that again. So these are some of the things that a court can order. And as you can see, this is not criminal. So they're not putting anyone in jail, they're not locking anybody up. This is them saying, as a government, these are the things that you should be doing to fulfill your obligations. And that's what the court can order. Yes.
So what enforcement mechanism is there if these countries don't comply with what the court requires?
Yeah, and that's a very good question, because what we'll see is that there are very, very limited enforcement mechanisms when it comes to some of these things. So with the International Court of Justice in particular, there's monitoring by the court to make sure that the country actually respects the judgment. And if the country doesn't respect the judgment, they can bring this to the UN Security Council and have the UN Security Council try to enforce through a resolution of the UN Security Council. Now, that becomes a problem because our UN system and the UN Security Council system are very, very politicized. You have countries that have veto power on the UN Security Council, so it's not always obvious that the UN Security Council is actually going to enforce something or not. So again, you're highlighting something that for me as a lawyer that works in international law is a really, really difficult thing, which is no matter how much you fight, no matter how much you try, and even if states manage to bring a case against another state, at the end of the day, if a state doesn't want to respect it, there are very few ways of actually enforcing a state to respect those rules. And we'll see that, and I think you will have seen that with some of the most recent cases out of the International Court of Justice. There's cases with Russia, and some cases have even chosen not to participate in proceedings. So they've chosen to just not show up. So that's one unfortunate aspect of a state consensus-based system. Yeah, which I know is not the best answer in terms of the goals that we have today. So I'm a little bit over time for the break, but I think it'll be interesting to just give you a few examples. I won't go super in depth into these examples, but if any of these examples are interesting for you, you can look online and you can learn more about them, or you can ask me questions in the break, and then we'll break before we talk about the next mechanism. So I thought one example that would be very interesting for you is actually a recent case. Is there anybody in the room that is from Afghanistan or from the Hazara community at all? Or? Nice to meet you. So this might be an interesting case for you. Canada, as well as Australia, Germany, and the Netherlands have vocalized their intention to start a case against Afghanistan under the Convention on the Elimination of Discrimination Against Women and Girls. So they have decided that together, these 4 states are going to bring a case against Afghanistan for the breach of the obligations under this convention to not discriminate against women and girls. They initiated this in September of last year. They haven't formally started proceedings yet, but they've expressed that they will, and they're in a negotiation phase right now. And of course now with the Taliban coming into power and not being formally recognized as the legitimate government, there are a lot of different issues at play here. But this is something that is interesting to watch because Afghanistan signed the convention in 2003, which means that anything that's happened since 2003, they can potentially adjudicate in this type of a case. And so if there is a case like this happening, and let's say Canada is one of the countries that is bringing this case, the community, the victims and survivors in Canada from Afghanistan can try to express their wishes to the Canadian government to make sure that the human rights violations when it comes to discrimination against women and girls is that the government is aware of what they've lived through, that the government is aware of what's happened and can incorporate that into potentially any case that they bring forward and potentially offer evidence, right? Because you need evidence in this type of a case. And so it's the victims and the victim communities that might have some of the best evidence available to share with governments to make sure that these cases can come. So that's one example. That's a recent example. There's also a very famous example, again, with Canada taking the lead with the Netherlands and bringing a case against Syria under the Convention Against Torture. And I think what's really interesting about these two cases is Canada doesn't necessarily have a personal country interest in bringing this case, but clearly they believe that something like torture or something like the systemic discrimination and persecution of women and girls is an issue that is really fundamental and matters to them as a country, that they're willing to spend their resources and their time and their energy to bring cases like this on the international stage. And the reason countries like Canada or the Netherlands are willing to do it is because victim communities have advocated and raised awareness in the countries that they are, diaspora communities, and have said, you know, there's a large community here, this matters to us, and as a country who values these issues, it's important for you to show that by bringing cases like this. And it works because countries like Canada and the Netherlands have done this. So this case is, it started in 2023 against Syria under the Convention Against Torture. And now that the Assad regime has fallen, it'll be interesting to see what happens. It's still in the middle, the case is still in the middle of the determination, and Canada has asked for an extension because of all of the developments that have happened, but it's an ongoing case, and we'll find out soon what will end up happening with this case. So it's an interesting one as well. There's also the case that the Gambia brought against Myanmar for genocide. So again, you have a country like the Gambia that ostensibly has no connection to Myanmar or to the Rohingya Muslim community there, but they wanted to bring a case because they represented 57 members of the Organization of Islamic Cooperation, and they decided that it was important for them, on behalf of this coalition of countries, to bring a case against Myanmar for the genocide that was being committed against the Rohingya there. And so that case was initiated back in 2019, and that is also an ongoing case where we're waiting to find out what will ultimately happen. And very quickly, there's the case that South Africa brought against Israel. Again, another situation where it's not obvious about why South Africa would bring this case, but South Africa itself has a history of apartheid and a history where they have been treated, their populations were treated in a way that now a lot of people are pointing to Israel as creating the same type of systemic discrimination, apartheid, colonialism, and genocide. And so they brought a case against Israel, and that is also an ongoing case. So these are some examples of how human rights can be addressed through the International Court of Justice, but they're being addressed in very specific ways by states who are willing to bring cases against other states. And there are very specific legal mechanisms or legal procedures by which they can do that, but they can't necessarily do that on all issues. And I know that for Northern Justice Watch, crimes against humanity is a really focal point. And so one thing that I think is also really important to note here is that we do not have a treaty on crimes against humanity yet, right? There's no international convention or treaty. Many, many groups, civil society groups across the world have been advocating and working on trying to get a crimes against humanity treaty, and that conversation is happening at the United Nations, and it is an ongoing dialogue, but there has not actually been a crimes against humanity treaty. So in this current moment, there's no treaty to look to try to bring a state to the International Court of Justice for crimes against humanity. So I will pause here for a break. And if you have any questions, feel free to ask me during the break, or you can ask me after the break, and we'll continue after them. Thank you so much. It's okay? Yeah. Thank you. Okay. So I'm going to move on to the next part of the session, which is to talk about the International Criminal Court. And so I guess I'll just start off again on asking all of you what kind of court the International Criminal Court is. Cool. It's okay. Is that better? Yeah, there we go. Can anyone answer what kind of court it is? Yes.
It's to bring cases against individuals for the crimes they committed.
Exactly, and it's in the title, right? It's a criminal court. It's to bring cases against individuals for crimes. So that's entirely correct. And that's different than what we just talked about earlier today, right? It's a criminal process. It has a very different type of system and set of rules. And ultimately, it's going to be able to offer different remedies because it's a case against an individual for potential crimes that have been committed. And it's not a civil case against a state or a government. So who can bring a case to the International Criminal Court? There's a clue on the screen, but does anybody want to take a guess at who can bring a case to this court, if it's a criminal court? Kind of. We got an international lawyer. A specific type of international lawyer can bring a case. In Canada, if someone commits a crime, who brings the case against the person? The prosecutor. The prosecutor, right? And that's the exact same thing with the International Criminal Court. There is an office of the prosecutor that is within the International Criminal Court. There's a chief prosecutor, and it's the prosecutor that is involved in the investigation of these crimes and ultimately in the prosecution of crimes against specific people that they have identified that have committed international crimes that fall within the jurisdiction of the court. So as a victim, as an individual, you can't just go to the court and bring a case against a person. The prosecutor has to decide. The prosecutor has the authority and the discretion to make a decision about whether to bring a case or not. And that decision is really going to be based on how much evidence is there available here. Do I have sufficient evidence that in a court of law, I can prove beyond a reasonable doubt that this person committed these crimes? So there are standards. There are evidentiary standards. There are standards for which the prosecutor operates. And so it's the prosecutor that has to bring a case. And on what basis does the International Criminal Court operate? There's a clue here. Does anybody want to... We talked about it a lot, and people use this terminology a lot, but sometimes they don't know what it means. But genocide's an example of it, yes. It's international crimes, and the international crimes are defined in the Rome Statute of the International Criminal Court. So the Rome Statute is an example of a treaty that was negotiated amongst countries. They drafted a treaty, and countries signed on to the treaty and said, we voluntarily become members of an international criminal court that has the authority to prosecute, to investigate and prosecute these specific crimes. So there are 4 specific crimes that fall within the Rome Statute, and these are the only crimes that the International Criminal Court can actually investigate and prosecute. They are genocide, they are crimes against humanity, they are war crimes, and very recently there's an additional crime, which is the crime of aggression. And what's important to know is that these terms are legal terms, and they're defined very specifically in the statute. And so you will have additional sessions down the line, and you may have already had some sessions before through the live series about exactly what these terms mean. But it's important to know that these are the only crimes that the prosecutor can investigate and can potentially prosecute an individual. If it's not one of these 4 crimes, then that's not something that the court has the authority to do.
So does the prosecutor proactively does this?
Yes.
By themselves, or does somebody else need to bring it forward?
That's a very good question. So the question is, does a prosecutor just by their own decision bring cases, or can other people bring cases? So there are phases to an international criminal law case. And the very early phases of a case are the pre-investigative stages. So there's something in the court called preliminary examinations. And actually, there is a process, and we're going to talk about it in a moment, but I'll just address it now, where individuals, victims, but also lawyers, human rights activists, people can make communications to the Office of the Prosecutor of the Court under a very specific procedure to share information about what they believe is the commission of crimes that fall within the court's jurisdiction. And the Office of the Prosecutor collects all of this information, and they start or initiate what's called a preliminary examination to look into that information or that evidence and determine, do I believe that this information amounts to a crime under the jurisdiction in a country that the court has the authority to act in, and in a time period that the court has the authority to act in. So they do a preliminary examination to make sure that the criteria is met, that they can actually do something. And if they see that the criteria is met and that there's sufficient information and evidence, then they can choose to then open an actual investigation. So there's a preliminary examination that can turn into an investigation, and then the investigation, if there's sufficient accumulation of evidence and information against a specific person for a specific crime, can then lead to an arrest warrant and then a potential prosecution. That's the life cycle. And so there are individual victims and individual people, human rights monitors, human rights activists, people who research what's happening. They can submit information to the court, but actually other states that are members of the court can also send a referral to the court, and that also has a lot of weight before the prosecutor. So if they refer a situation, and there is an example of this, Canada was involved with many other countries, and they referred the situation in Venezuela to the court for investigation. It carried a lot of weight because it was a member state of the court that said, hey, Mr. Prosecutor or Mrs. Prosecutor, we want you to investigate this. And so it led the prosecutor to have a preliminary examination and determine whether there was enough information for them to actually build a case. A couple things that are also important to keep in mind is that only cases where the crimes occurred on the territory of a member state or by a national of a member state fall within the authority of the court. So like I said earlier, we're talking about international law, which is states voluntarily choose to become members and to sign up to certain obligations. So a country like Canada has signed the Rome Statute, has incorporated the Rome Statute into our domestic law, and has said, we want to be a member. And so if a crime occurred in the territory of Canada or by a Canadian, the court would have authority. But the United States, our neighbor in the south, they haven't signed this treaty. So if something happens in the US or by a US national, generally speaking, the court would not have the authority or the ability to investigate or prosecute because the United States has not signed this. Now, there are some exceptions, and I'll talk about a few examples down the line, because sometimes you will have the national of a non-member state committing a crime on the territory of a country that is a member. And that opens up some opportunity for the court to actually act, because if even a portion of the crime was committed on the territory of a country that is a member of the court, then the prosecutor can investigate it. And so these are the different ways in which it triggers the authority of the court to do something. And that can be really frustrating because a lot of times you'll hear people, they go, why isn't the International Criminal Court doing something? There's human rights abuses in this country, in this community, this is happening. And the reason that the court sometimes cannot act is because legally it actually does not have the authority to act in every situation. There's also one other really important piece of the limitations of the court, and this is what we call the temporal framework or the time frame, okay? So what we have, there's a concept in criminal law that a crime can only be investigated and prosecuted from the moment it was a crime and only moving forwards. You can't go backwards and say, you did something before this was actually prohibited, and we're gonna investigate you after the fact, right? So because it's a treaty that was negotiated and it was signed and it entered into force in 2002, that is the time cutoff for the court. Not necessarily for other mechanisms, but for this specific court, the prosecutor can only look at international crimes that were committed after this date and onwards. And there's another complication because not all countries have signed up to the court when the court was first established. Some countries signed up to the court maybe 5 years, 10 years after the court was established. So it's from the date that they choose to become a member of the court and that they declare that the court is allowed to investigate from this date and it's only moving forward. So in some cases, you'll see that the court can only investigate as of 2010 or as of 2020. So this is also a limitation around what the court can actually do and what the prosecutor can do. And that's going to be determined on a case-by-case basis based on the country and the way that the country has engaged with this treaty specifically. So what is the role of victims in this context? So what's interesting about this court is that there are different legal systems across the world. In Canada, our criminal law system is a common law system. It comes from a British Commonwealth system. But there are many countries in the world that have a civil law system. In Quebec, in the province of Quebec, it does have a civil law system. And there are also other countries that operate under an Islamic law system or other types of legal systems. The court has tried to be a very open court that incorporates different types of legal systems into the way that it operates, and so it functions a little bit differently than what we might see in a Canadian criminal case. And one of those differences is that there actually is a role for victims at the International Criminal Court, whereas there isn't always a role for victims when it comes to criminal law. Because criminal law is essentially the state bringing a case, a prosecutor bringing a case against an individual and saying, you broke rules that we have, criminal rules, and therefore we are going to punish you because we don't want you to commit these crimes and we don't want other people to commit these crimes. We want to deter people from breaking these rules, and so it's a case that is usually the state against the individual, and victims don't always have a role, even though they were the ones victimized by a crime, whether it's theft, whether it's murder, whether it's, an assault. Victims often provide evidence. They often are the ones that have been harmed and they can give information, but there's not always a role for victims. But that's different in the International Criminal Court system. There is legal counsel for victims so that victims who are determined to be a victim in a very specific case that is being brought by the court can actually participate in the hearings. They can bring evidence, they can bring information, and they can actually have a participatory role in a case like this. And there's also a trust fund for victims so that if a person is convicted at the end of this process, then there can be a form of compensation to the victims or sometimes even to broader victim communities based on the outcome of the criminal case. So unlike the International Court of Justice that we talked about a bit earlier, where there was a very, very limited role for what victims could do, at the International Criminal Court, there's a slightly broader role for victims. It's not perfect. Victims don't have access to everything, and they can't force a case to be brought. They can't bring a case themselves. But if the prosecutor does bring a case and they happen to be a victim of that very specific incident or case that is being investigated, then there are opportunities for victims to participate. There's also, like I mentioned earlier in response to your question, there's also the opportunity for victims to send information to the court, to the prosecutor, before a case has been officially initiated or even during an investigation of a case, if they believe that they have information that can be relevant to the prosecutor in the investigation. So they can send evidence, they can send information, they can send documents, they can send pictures, they can send videos, they can send information and say, hey, prosecutor, if you're looking at this situation, so for example, if you're investigating Afghanistan, I have information that I think is relevant to your investigation. Please look at this and incorporate this into your case. And the prosecutor will take that information. There's no guarantee that the prosecutor will actually bring a case based on that information, but it will help them in determining the exact scope of what they choose to do and how they choose to bring a case in court.
So can you, just clarification question. So can you bring the bring the case against those who actually committed the crime, and not bring it against the prime minister or the leader of the country.
Mhm.
Somebody else may have done it, but
Yeah.
it is under the direct direction and instruction supervision of the leader of the country. So
Yeah.
how does that?
You are on fire. That is a great question. You've had very good questions. So what you're bringing up is a concept, a legal concept, that's called command responsibility. And so what this concept is, just very, very briefly, is that you sometimes will have a soldier, someone who is lower in the ranks that is actually committing a crime. The guard in the prison is the one actually committing the torture, or the soldier in the field is the one actually, burning a house or firing on a person. But they are often acting under the command or under the directions of their superiors. And so a court like the International Criminal Court, and this is actually a very important part of this court, it's considered a court of last resort, and it's meant to be a court that really tries to go for the most responsible perpetrators of crimes. And oftentimes, it's not going to be the soldier or the individual that was given directions that is just a puppet of a larger system. It's going to be the head of the Ministry of Defense. It's going to be the president of a country or the prime minister of a country. And so there is a way in which those people can be held accountable under command responsibility if certain criteria are met. And those are actually the main targets of a court like the International Criminal Court. Those are the types of people that the court wants to prosecute, because a court like the International Criminal Court doesn't have infinite resources. They don't have infinite sources of money or capacity or people. They can't bring cases against hundreds or thousands of people that are committing these types of crimes. So strategically, they want to bring the most impactful cases, the cases that are going to have the most impact when it comes to these types of atrocities. And generally, that's going to be going after the person at the very, very top of the hierarchy or the command structure. So that's what this court does. So finally, when it comes to the International Criminal Court, it's also important to know what remedies are available. So as I mentioned with the International Court of Justice, it wasn't a criminal court, it was a civil court. So the types of remedies available were things like compensation or restitution, or orders for the state to do something or to stop doing something. So behavioral changes, right? What are some of the remedies that you think are available through a criminal court like this? Exactly. So again, we're looking at cases against individuals, not states. And the main remedy through the International Criminal Court would be to prosecute an individual, and it's a punitive remedy. It's to convict them and sentence them and put them in jail. And there are some other remedies available for victims. As I mentioned earlier, there's a trust fund for victims. So when any situation turns into a case, then what is possible is there's a trust fund for those victims, so that if there is a conviction, then there's a pool of money where states all contribute to it, or sometimes the perpetrator, if they have assets or they have money that has been confiscated, it goes into the trust fund, and then that can be paid out to the victims. On some very exceptional cases, the money has been paid out to communities or a broader group, not just the victims, and even when a conviction has been reversed. But generally, it's really attached to the actual case itself. So it's not every victim that will have access to this trust fund. It's attached to the case that the prosecutor eventually chooses to bring. But that is a remedy that is available. So I'll just give you one very recent example, because this happened on the 8th of July. So this happened last week, but there was a very, very public announcement by the International Criminal Court that they actually issued arrest warrants against 2 individuals in their Afghanistan investigation for their arrest. The first warrant was against the supreme leader of the Taliban. So again, we're looking at the command responsibility. And the second arrest warrant was against the Chief Justice of the Taliban. And the charges that they have brought forward against these 2 individuals, the charges inducing or soliciting crimes against humanity, of gender persecution, on two different grounds. On gender grounds, against women, girls, and people who are non-conforming individuals to the Taliban's concept of gender. And that's on gender grounds, but also on political grounds against any person that is an ally of women and girls, that works to help and support and advocate for women and girls, who's also targeted by the Taliban. So this is a very recent case that now they are hoping to arrest these two individuals, and if they're able to arrest these individuals, they will then bring them to court, and they will actually have a prosecution against these two individuals. So this is a very recent development. So I'm going to pause here for a moment for any very immediate questions you have before I turn to the UN human rights system. Does anybody have questions about the International Criminal Court? Or yes.
So you mentioned earlier that the U.S. has not signed on to the Rome Statute.
Yes.
They do not recognize the authority or the jurisdiction of the ICC.
Mm-hmm.
So this court is really not applicable to the most powerful nation in the world. So I'm just wondering if you have any comments on. I understand that there's so many accountability gaps within the international human rights and legal system, but I think within my work, I always get, that's always a roadblock where I'm very unhappy when I'm trying to encourage people to engage with the human rights system. So I'm just wondering if you had any thoughts about how to go about doing this when you have such a major roadblock with trying to bring the U.S., for example, to hold them accountable for any of their actions in the world.
Yeah, it's a really good question, and it's a really important question, and it's true. So a major superpower in the world like the United States, who is also very heavily involved in international crimes in many parts of the world, including now in their own country with what's been happening, the fact that they're not a member of this court, and not just that they're not a member of this court, they are actively trying to undermine the court. So I don't know if people have heard about this, but President Trump actually signed an executive order that imposed sanctions on the court, the chief prosecutor, 4 judges at the court, and now a UN Special Rapporteur, and we'll talk about the role of UN Special Rapporteurs, but specifically because the International Criminal Court was bringing a case against Israel when it comes to what's happening in Gaza. So the U.S. doesn't want themselves to be held accountable. They don't want some of their closest allies to be held accountable. And because they haven't signed the Rome Statute, the court technically does not have the authority to look at crimes that have happened in the U.S. or by U.S. nationals. However, and there are ways to be creative legally. There are ways to try to find opportunities for accountability within the system that exists and still acknowledge that the system is flawed. And a lot of lawyers do try to do this. So for example, with the Afghanistan investigation, for many years under the previous prosecutor, they were investigating the Taliban, they were investigating the Haqqani network, which is an offshoot, and they were also investigating U.S. forces in Afghanistan for the crimes that they also committed in Afghanistan. So that was an investigation that was ongoing, and it actually was one of the reasons that the U.S. became so aggressive with the International Criminal Court, because they said, we don't want you to investigate us. We don't want this. We think this is wrong. We're not a member of the court. And that actually was a turning point with this level of aggression that we're seeing with the Trump administration. The same thing with the Israel-Palestine investigation, right? Israel is not a member of the court, but the court is looking at what happened in Palestine or by Palestinian nationals, and because Israel's onslaught and bombardment is happening on Palestinian territory, then technically the crimes happened in Palestine, and so the Israeli officials can be held responsible because Palestine is a member of the court. So these are some of the ways that countries and individuals from those countries that haven't voluntarily signed up, these are some ways that there can be some form of accountability, but it is very, very tenuous sometimes, and it's difficult. And then you see the political backlash, right? And now we're in a moment of political backlash where countries like Israel and the U.S. are undermining the court left and right because they don't want to be held accountable. And I guess the question that you asked is what can we do? It is frustrating as a lawyer in this space, and it's frustrating for me to constantly have to tell different people, I'm sorry, but the court just can't do this, or I'm sorry, but these people, it's impossible to hold them accountable in this way. It doesn't mean that there aren't other ways to hold individuals accountable. So the organization I mentioned to you earlier, the Canadian Centre for International Justice, actually when George Bush was no longer president, but was traveling to Canada after the Iraq War, the Canadian Centre for International Justice, along with the partner organization in the US, the Centre for Constitutional Rights, they actually put together a case against Bush for universal jurisdiction for a criminal prosecution as a war criminal. And they submitted it to the Canadian authorities, but because, again, everything is politicized, the Attorney General did not allow that prosecution to go through, so the Canadians didn't actually arrest him, even though, based on the evidence and the information available, George Bush is a war criminal, right? And so it's really hard to see the hypocrisy and the double standards in the system that we have, because the system is a consent-based system, but it's also it doesn't exist in a vacuum. It exists in a very politicized environment where there are power imbalances even between states. And so those power imbalances are going to also show up in the way that these cases come through. So to come back to the Afghanistan example, the US was being investigated. There was a lot of pressure for them to stop that investigation, and ultimately the chief prosecutor in the end decided not to pursue the investigation against the US and really only focused on the Taliban. So we do have these 2 arrest warrants, and this is important, and it's good that this happened, but it's not the full picture of the types of crimes that were committed, and not all of the people that are most responsible are being targeted. So there are some, you know, it's tough to have to swallow that pill, you know? Was that helpful? Okay. Any other questions about this system or International Criminal Court? Yes. Is there a microphone?
These are the systems that has been created. I do something came on my mind about the whistleblowing. As you know, some of the government officials or some of them working in the governments has lots of information that could be as impact on the war crimes or on the human rights or anything else. So this will have a really put pressure on these people. Do they have any mechanism to protect these kind of people? Because if they reveal, it is the most serious case is the Edward Snowden case, and he has been exiled about 25 years. So it is very important for the government officials or working with the government to reveal these cases, because they see what's wrong over there.
Yes, you mentioned whistleblowers, right? And within the government. It's a very, very good question. And actually, most of the cases that we see at the International Criminal Court, when we're looking specifically at criminal cases, but also when we're talking about state-to-state cases, almost all of these cases would not be possible if there were not insider witnesses who have information about what is actually happening on the inside. Whether it's to be able to explain the hierarchies of power and command, who's actually responsible for what, or whether they have documents, memos, information, evidence about what's actually happening, and also the level of knowledge and intent behind this conduct. Insider witnesses in the context of international criminal law, which include whistleblowers, people within either the government, the political structures, the military structures. These are very key informants and people that can bring evidence and information to the court. So There are some witness protection measures and programs. They are not perfect. They are not ideal. It is a really big problem around the intimidation of witnesses or people that come forward and how to protect them. And it's an ongoing conversation that has been taking place specifically with regards to International Criminal Court and international criminal law. But these types of individuals are some of the most valuable sources of information for cases like this. And the prosecutor does welcome these types of people to give information and evidence. So you're highlighting the fact that to build a case like this, you need information from many different sources. As a victim, as someone who has been harmed by abuses in a very specific incident, I will have one type of information that is going to be valuable. I can tell you what happened, when it happened, where it happened, what happened to me, what happened to other people around me, and that describes the incident. But there's also something really important in criminal law, specifically in international criminal law, which is the linkage evidence, which is how to link that abuse to an actual person or to an actual authority figure that caused it to happen. And that evidence sometimes is harder to get. And so people who are on the inside are often going to have access to that type of information about who was there that day, under what command structure, who gave the directions, who ultimately had authority, and that helps to build the larger picture of who should be investigated and prosecuted through a system like this. So it's a very good point that you brought. Yeah. Okay, so I'm going to turn my attention now to the UN Human Rights System, but we do have a Q&A at the very end, so if any other questions come up, feel free to ask. The UN Human Rights System is massive. And I'm just going to look at the time. Okay, so I think what I'll do is I'm going to go through these a little bit more, kind of an overview of them. If any one of them is a bit more interesting for you, I can come back to it and explain it a little bit more. But the main thing is that the United Nations was set up as a forum, as a space for countries to try to resolve international issues through diplomatic means. So it's a place where countries come and on a variety of topics. Some of them are human rights, some of them are development, some of them are environment and sustainable goals, some of them are economic, right? There's a lot of different issues that matter to people to come and to discuss these as part of what we are known as the international community. And one of those themes that is cross-cutting across so many areas is human rights. And there is a really robust human rights system within the United Nations that does offer some accountability opportunities. So there's something known as the UN Human Rights Council. And within the UN Human Rights Council, there are some mechanisms. One of them is the Universal Periodic Review. One mechanism is known as the Special Procedures. And then there's also investigative bodies that are ad hoc bodies for specific issues where there are some investigations carried out by experts hired by the United Nations. So these are the main accountability mechanisms through the UN Human Rights Council. So the Universal Periodic Review is basically a process by which every country that is a member of the United Nations will get a very comprehensive review of their human rights record over a 5-year period. So over 5 years, every single country is going to be reviewed in some capacity. And it is an opportunity for states, so for other countries, to ask questions or to make recommendations to other states about what they think they should do. So as an example, if a state hasn't signed on to the Rome Statute, a state can say, you know, you need to sign on, or we recommend that you sign on to the Rome Statute so that you can fulfill your human rights obligations not to commit genocide, war crimes, crimes against humanity. So the states can make recommendations, but also individuals, human rights advocates, non-governmental organizations also have an opportunity to present information to the UN Human Rights Council and to bring information to light about human rights issues that they also want highlighted or examined. And that's one way that as a victim or as somebody from a community, if you want a specific issue to be addressed, there are ways of either doing it through nonprofit organizations and non-governmental organizations, or through providing information to other states and asking them to bring up these issues. So I have very, very brief examples. So for example, Afghanistan's 4th cycle under the UPR, under the Universal Periodic Review, was completed in April 2024. And so their next cycle is going to be sometime in 2029, because it happens every 5 years, because every country gets reviewed. And so just some examples of what Canada has said or has recommended. So Canada, for example, brought up the issues of Hazaras. They recommended to Afghanistan to cease discrimination against LGBTI people, ethnic, linguistic, and religious minorities, including the Hazaras, Sikhs, Ahmadis, and other marginalized groups. So for those of you who are here in Canada, I think what's interesting for you is to know that if Canada is participating and they care about certain human rights issues, one thing that you can do as a community is to actually bring attention to the Canadian government ahead of the UPR of the country that you are, that is important for you. And you can actually bring issues to their attention and ask them to press on those issues. And that's one way that you can engage in this. There's also the example of China. So their 4th cycle was completed in January of 2024. So their next cycle is going to be in 2029. And actually in the recommendations that Canada also made, they mentioned specifically the Uyghur community and the Tibetan community and other groups that have been marginalized or whose rights have been violated by China. There's also Ethiopia. So the 4th cycle was completed in November of 2024, and their next cycle will also be in 2029. And again, there were recommendations by Canada, specifically around investigating, prosecuting, and holding perpetrators accountable of human rights violations in the country. And finally, there's the example of Turkey. So their 4th cycle actually happened in May of this year, and the documents are not public yet because the Human Rights Council is still considering all of the information that they received. So that information and the outcomes of that review will be made public in the next few months, and their next cycle will be in 2030. So that's an example of the UPR, the Universal Periodic Review. There's also something called the UN Special Procedures. So this is, again, a different set of opportunities or avenues to get specific issues or specific countries to highlight the human rights abuses in those countries. There are 2 types of special procedures. There's thematic mandates. So this is like specific themes that you have experts that are focusing on those themes. For example, arbitrary detention is a theme, or business and human rights, so how corporations may violate human rights. They have cultural rights as a theme, so the rights and obligations of states to respect culture and ethnic and different cultural minorities. They have enforced disappearance as an example, or even arbitrary execution. So you have a special expert that has been mandated by the UN to focus on this issue, and that expert will visit different countries, and they can actually do, I'll give you an example, they can do a variety of different actions. They can visit countries and actually try to get information from the government of those countries, from civil society in those countries, and learn about the situation. They can also send communications to the country, ask questions. If there's for example, if there's a case of arbitrary detention of a very specific individual, they can ask the state, tell me about this person who I understand is arbitrarily detained. What is going on? Are their rights being respected? Is there due process? So they can send bilateral communications to states to try to get information about specific cases. They can also issue press releases. If they think that there's a serious issue happening, they can issue a press release, and you can see some examples right now, press releases that were issued on China, on Turkey, on Afghanistan, where the experts have said, hey, this is something that is an urgent issue in the country. And they also submit reports to the Human Rights Council based on the information that they collect throughout their mandate. So as I mentioned, there's thematic topics, but there's also country. So there are special rapporteurs that are designated for specific countries. And not every country is represented, but there are about 14 country mandates. So for example, Afghanistan has a country mandate, Iran has a country mandate, Eritrea has a country mandate, Syria does, Somalia does, Palestine does. So there are a variety of country mandates where the special rapporteur focuses just on that country. And so they often ask civil society groups, they ask victims, survivors, communities to give them information so that they can issue these reports, so that they can ask questions of the government, so that they can engage in a dialogue and try to get the governments to give them information about how they are or are not respecting human rights. I think I have some oh no, I don't have examples, but if you want examples, I can give some later. The third kind of category under the UN Human Rights Council is what is called an investigative body. And so the investigative bodies are set up by a resolution of the Human Rights Council, and they're usually set up to investigate a very specific issue or sometimes specific events or incidents that have happened that warrant an independent and special investigation. And so here you have, for example, some examples of ongoing special ad hoc investigative bodies. There's currently an investigation into Sudan, into Belarus, into Iran, and into some other countries. And it's really important because they're not necessarily investigating everything. Usually they're investigating something very specific that they were asked to investigate. So I'll give you the example of Ethiopia because this was a special investigation that took place between 2021 and they released their final report in 2023. But basically, this was an International Commission of Human Rights Experts on Ethiopia that was set up in 2021 with 3 human rights experts that were mandated to conduct an investigation into violations of international humanitarian law, so whether war crimes were being committed in Ethiopia, and violations of international refugee law, so whether refugees and their rights were being respected in Ethiopia since November 2020 when the conflict erupted in Tigray. And so part of their mandate was to investigate and also to collect and preserve evidence from victims and from different communities that were able to give them information about some of the human rights abuses that were happening and specifically the violations of international humanitarian law. And they published their final report in 2023, and in that report, they determined that all parties to the conflict were committing war crimes and crimes against humanity. Now, I'm sorry? Yes.
But crimes against humanity, the Tigrayans were not.
Yes, that's true.
And then there was a potential. Anyway, yeah, that's a critical distinction.
Yes, okay, thank you very much, indeed. So I guess the point for me is that these are war crimes and crimes against humanity are international crimes. And so some of the parties engaged in these crimes in different ways during the conflict. And what the investigative body was able to do was to report on their investigation, to collect and preserve evidence, and to come to some type of a determination. Now, it's not necessarily a legal determination based on a court of law, because it's not a court, but what it does is it actually collates and collects evidence at a threshold, at a standard that is credible, that then can be used as part of the evidence or the body of evidence for other types of accountability mechanisms. For example, if there was to be an international criminal law case or a state-to-state case, this is a report that ultimately can be used for that purpose. But it's not a legal court, and therefore there's no power of enforcement, there's no power of prosecution, but it is a way for victims to give their information to experts and to be heard about what they experienced. Now, there's another system within the UN human rights system, which is the UN treaty bodies system. And the UN treaty bodies, essentially there are some core human rights treaties and conventions that countries have signed. And based on those core conventions, there are committees or bodies that are designated to monitor the compliance of countries with that particular convention. So I've listed them here on the slide, but basically you have, as an example, the Committee on the Elimination of Racial Discrimination. They monitor countries' compliance with the Convention on the Elimination of Racial Discrimination. Or you have the Human Rights Committee. The Human Rights Committee is responsible for monitoring the compliance of countries with the International Covenant on Civil and Political Rights. You also have the Committee Against Torture, which is based on the Convention Against Torture, the Committee on the Rights of the Child, and so there are multiple different treaty bodies, and their role is to really monitor all of the countries that have signed and ratified those treaties. Are they actually complying with the treaty? And there are some opportunities, depending on which treaty and whether a country has actually allowed for this process, but there are some opportunities for actual victims and survivors to bring individual complaints against a country through the treaty body. And I'll give you one example on a case that I actually worked on personally. So when I was the legal director of the Canadian Centre for International Justice, one of the types of accountability avenues that we used for some of our clients was the Human Rights Committee, based on the International Covenant on Civil and Political Rights. One of our clients was an individual from Sri Lanka who actually was tortured in Sri Lanka and imprisoned arbitrarily for 3 years after the Civil War, and then was a Canadian citizen and came back to Canada, and we brought a complaint on his behalf to the Human Rights Committee under the Covenant on Civil and Political Rights, because the Covenant on Civil and Political Rights prohibits the use of torture by a state. So we filed the complaint in 2013. It took 3 years for the Human Rights Committee to actually evaluate and review the information that we provided. Because what happens is when you file a complaint, the committee then goes and asks the country to also give their version of what happened or ask them to respond to the complaint. So there's a level of engagement to make sure that they have all of the information and then they come to a determination. Some countries will engage with the committees, some countries will ignore and not engage with the committees, but this is a process that is available. So it took 3 years, and in 2016, the Human Rights Committee concluded that actually Sri Lanka did violate the convention in the case for our client, and actually ordered the government to provide adequate remedies to our client, including compensation, but also to investigate what had happened to him and to try to investigate the individual perpetrators that committed the torture, to punish them and to prosecute them. Sri Lanka did not respond and did not actually implement what the Human Rights Committee ordered. So this goes back to the original point that has been brought up a couple times, that what is really a systemic problem in international law is that enforcement is one of the hardest parts of it, but at least there is a report, an order out there by a UN Human Rights Committee that actually validates the experience of a person. And for some victims, just the knowledge, the acknowledgement, the validation that somebody out there has said, yes, what happened to you, we understand what happened to you, we know what happened to you, and we agree that it was wrong, that also is a form of justice that can actually go a long way for a lot of different people who want to feel heard and to feel seen when so many people are unwilling and unable to actually listen to them. So this for us was a really successful outcome in some ways. And this is just one example of how victims can avail themselves of this type of a process. And the very last note that I want to end on, because I think this is a really, really important thing to keep in mind, is that there are international justice NGOs, non-governmental organizations, that are set up specifically to help victims access these mechanisms. Because as much as these mechanisms, or at least the ones that are set up to be accessible to victims, they are very complicated to navigate. They are very technical. The procedures, the legal jargon, how to do it, who to direct it to, there's a lot there that is just very hard for an individual to be able to fully understand how to access. And so there are lawyers like myself, there are community groups like Northern Justice Watch who are trying to educate individuals and give them information that can empower them, but it is very difficult as a victim to just bring a case by yourself. And so a lot of international lawyers work for these types of non-governmental organizations with the mandate specifically to work with victims and survivors, to work with communities, to hear what has happened to them, and to help strategize together, to co-design what would be effective and appropriate accountability strategy, or an avenue that might be available, or just a way to try to address the human rights abuses that have happened. And so if any of you are interested, if any of you feel that you have a case that you want to do something about, I highly, highly encourage you to connect with lawyers in your community, or groups like Northern Justice Watch, or even people like myself. This is what I do all the time, and to actually talk to an expert that can help navigate the system with you. Because otherwise, it's not a very accessible system, and it is very, very difficult to come and do it without the technical legal knowledge. But there are resources available, and I'm sure Northern Justice Watch will also provide resources to you if there are any specific questions that you might have. But it's a really important area of this work that I think is important to keep in mind. You're not expected to do this work. There are lawyers that are doing this work, and it's important to connect with them to get it done properly. So I now will open it up to you for questions. I know there's maybe a little bit of a break. I spoke a lot. There's a lot of information that I've thrown at you. Thank you for being so attentive and for being engaging with me and for asking questions. I really appreciate being here with you. And if you have any questions, please bring it up in the Q&A. There's no question that is a bad question. And I hope to hear from you then.
So would you prefer to restrict it to questions, or would you like a few-minute break?
I think we can do a short break, or maybe people can take some snacks and come back and we can have an informal Q&A while you're having some coffee.
Let's do that.
Okay.
I was going to ask a question in person, but I thought some people might learn from this as well, so I thought I'd ask you now. Thank you so much.
Thank you very much for the question. So, what other remedies or what other avenues are available? Yeah? It's really tough. It's really tough when you're coming from a country that doesn't actually ascribe to a lot of the international legal norms and conventions, because it does limit what accountability avenues are available to hold them accountable. That being said, I do think it's important to also remember that when we're talking about a legal accountability, we're talking about a very small piece of a larger pie in terms of what is needed in a situation of ongoing conflict. As an international lawyer, I usually deal with situations after they've happened, and all I can do is look at something after the fact, usually, and then say, okay, this was genocide, this was war crimes. What can I do? Can we punish somebody, right? There's a punitive system that we have in terms of criminal law. Can we punish the state? Can we punish a person? What can we do to get compensation or to help the victims? But it's always happening after an atrocity has happened or human rights abuse has happened. There's very little as a lawyer that can be done to really deal with something that is ongoing in the moment of conflict. I mentioned in the International Court of Justice, through the International Court of Justice, I mentioned provisional measures. This is one way that lawyers have tried to have more immediate impact, which is to ask a court to issue something right away in the middle of conflict. But even then, countries, as we know, don't respect it. They don't listen. So the role of an international lawyer can often feel very demoralizing because there's not much that can be done to actually help people when they need it. And when you have situations of conflict, what's needed often is for the conflict to end, for a ceasefire, for an end to the actual belligerent conduct. But you also have people that have needs, health needs, medical needs, psychosocial support needs, housing needs, food needs. There's a lot of immediate humanitarian stuff that also is important that a lawyer can't address, right? So I just want to acknowledge right off the bat that even when we talk about international legal accountability, we're talking about such a small piece of an otherwise big, big issue that needs to be addressed on multiple fronts by multiple different people and groups. So with something like what's happening in Tigray, it is sad that there isn't more that can be done right now. There is diplomacy internationally in terms of what's happening among states at the UN, other forms of bilateral diplomacy, trying to put pressure in some ways or not. But at the end of the day, a lot of conflicts, they're ongoing because somebody is benefiting from the conflict. Someone is getting enriched by the conflict. And so I was just having a chat earlier in the break about the financial side of conflict, but I think it's a really important piece of the puzzle that there are financial incentives for why conflicts are happening, and there are people that are contributing because they're getting a financial benefit. So there are corporations, there are companies that are either involved in supporting states, in sending weapons, manufacturing weapons, in providing fuel and oil and gas and other things that are needed for conflicts to continue, that are providing jets and drones and aircrafts and technology. So these are also other actors beyond just the state that are allowing states to commit these types of atrocities. So one creative way that you could try to think about accountability is if we don't have access to a state because the state is not involved in this international space, are there corporations and companies that are supplying the state, that are supporting the state, that we can try to advocate with or hold them accountable or somehow pursue them? There's also other states, right? So, for example, in this situation, Ethiopia or Eritrea or what's been happening in the region generally, these countries don't operate just on their own. They get support from other states. Other states are also helping them. They're providing money or they're providing technology. Sometimes they're providing intelligence, right? So sometimes there are also ways of trying to hold other states accountable for how they're complicit. And this is something that came up in the South Africa versus Israel case on genocide, because many countries, including Canada, have signed the Genocide Convention. And one of the obligations is to not contribute to genocide. And so a country like Canada is sending weapons and arms to Israel, and then there is an ongoing case where there is a plausible genocide being committed. Canada is aware. There is a way to make a case that actually Canada can also be held responsible for supplying weapons or supplying money to a state that is now involved in international crimes. So when it comes to Ethiopia, who are Ethiopia's allies? Who are the countries that are actually supporting Ethiopia, and have they signed on to treaties? Have they signed on? The UAE. So there was a case, actually Sudan brought a case against the UAE at the International Court of Justice because they claimed that the UAE was supplying money and weapons to the RSF in committing genocide. Unfortunately, the UAE was not So the UAE did not accept the court's jurisdiction in certain ways, so there were some technical reasons why they were not able to be successful with that, but this is a strategy that has been employed by states, and this is a way to look at it. So there's countries like the UAE, there might be other countries. So looking at what those countries have actually signed on to, what treaties they have obligations under, can open up certain avenues as well. And also, the other thing, the third kind of other creative way to do this is something that I think really deserves its own seminar, and maybe there will be a seminar coming up on this specifically, but there's a concept in international criminal law known as universal jurisdiction. And universal jurisdiction is basically a legal concept where countries that have a domestic statute that gives them the authority to investigate and prosecute people for committing international crimes in a different country, but they're actually, if they are in the territory of a country like Canada, they can be investigated and prosecuted. So this allows national courts and countries specifically to look at how other people are committing abuses abroad and making sure that those people, if they are in Canada or if they're in a country that has this, they're also going to be investigated and prosecuted. And then there are also other non-legal but political tools such as targeted human rights sanctions. This is something that Canada has used quite a lot. where they sanction individual people that are members of a government, that are agents of a government, for corruption or for committing gross human rights violations. So if those people have assets in Canada, if they have bank accounts in Canada, if they have property, those assets get frozen, and then there's ways of actually repurposing those assets. And we can see in the case of Ukraine, Canada has been very active when it comes to targeted human rights sanctions in trying to target Russian entities that are involved in what's happening in Ukraine. So there's these other mechanisms that are not technically international accountability mechanisms, but they're other creative ways of trying to seek accountability in some capacity for human rights abuses. Yeah.
Any other questions, comments?
I'll go there first, then I can see you.
About the thing, you said that, you said that the supreme leader of the Taliban is has an arrest warrant.
Mm-hmm.
How would that go? Like, let's say he's arrested. Like, how would the legal actions be?
Okay. If he's arrested is a very big if. And I'll give you the case of Omar al-Bashir of Sudan, who has been wanted by the court for, I want to say, over a decade, even more, but has not been arrested. So all of the members of the International Criminal Court have an obligation to cooperate with the court, especially if there's a warrant for arrest out for an individual, which means that if someone with an arrest warrant, such as the Supreme Leader of the Taliban, travels to their country, they have an obligation to extradite that individual to The Hague, to the custody of the court, so that the case can be brought forward against those individuals. Because generally with criminal law, they don't do cases when the person is not physically in the courtroom, right? Because we have due process requirements that are part of human rights to make sure that if there's a case against you, you have a right to also engage in that process. And so they won't actually bring the case in court if the individual is not physically arrested and there. And so states technically have an obligation to arrest an individual that happens to be on their territory if there's a warrant for arrest out for them. But what we've seen, because the world is so politicized, is that a lot of states don't actually respect this. And we saw this a lot when it came to Omar al-Bashir, who was traveling to other countries because as the head of a state, there are diplomatic engagements, there's diplomatic missions, and states that were members of the court were not extraditing him to The Hague. So that's one barrier, and that's a really big issue when it comes to active conflicts or when you're going after leaders of countries who are still in power. So the case against Benjamin Netanyahu or the case against Vladimir Putin, it's going to be very, very difficult to get them to actually be arrested. But if they are arrested, if they do end up being extradited to The Hague, then they're treated like any other person that would be arrested. They have rights. They have due process rights. They have a right to counsel, so they can choose their own defense counsel, or they can be assigned a defense counsel. And basically, it will be very similar to what we see in a domestic criminal process, where there will be an indictment, then there will be charges that are laid against them, and then there will be preliminary motions and ways that they will start opening up the criminal case and actually having a hearing and a trial. Ultimately, they'll have a trial to be able to determine whether this person is actually guilty or whether they are not. Mm-hmm.
Hi again. First of all, thank you so much for this really informative session. I know we've been speaking quite a bit at length about how Canada has participated within this whole international accountability system and how Canada has helped in these certain cases. But I wanted to ask a question about how to hold Canada accountable for its failure to uphold our education campaign to counter, the harmful narratives that are out there about people who are experiencing homelessness. And then one of the strategies that we have envisioned is filing a UN human rights complaint. And I understand that in order to do that, you have to demonstrate that you've exhausted all local and domestic avenues. So I guess I know I'm rambling right now, but I guess my question really is, at what point then are we able to file? Because I know that we've also discussed charter challenges, and I think, trying to build up our record of the demonstrated, efforts in order to show at the UN level that we've undertaken these efforts. I'm just wondering, in your professional opinion, how do we go about doing this? At what point are we permitted to really file? Because at the UN level, I understand that it's really about investigating the most egregious cases of human rights violations. So I was just wondering if you had any thoughts about how to go about doing that.
Thank you so much. That's a really great question. And I think your question highlights a very important aspect of the international system, which is that it is meant to be complementary to the domestic system, and it's meant to fill gaps that the domestic system doesn't account for. And therefore, a lot of the remedies, a lot of the avenues that we have there, one of the requirements is that you've actually tried to address it locally or nationally, right? Because that's where it happened, and that's the authority or the space in which you'll be able to have the most impact. And only where a state is then not able or not willing, or there's certain reasons why you are unable to access justice or remedies domestically, can you then bring this to the international system, right? So it is something that is applicable actually to the International Criminal Court as well. There's a concept of complementarity under the International Criminal Court where you basically, it's a court of last resort. And so if a state is unable or unwilling to investigate that crime themselves, when it happens on their territory, only then is the court able to do it. And there's a similar thing with the UN system with some of these where you have to exhaust local remedies to be able to actually access them. So that's just a preamble for those who don't know this, that this is a requirement. Now, what can be done and how you think through what exhaustion of local remedies looks like, it will vary from state to state, from country to country, because some countries have more robust legal frameworks and opportunities and ability to actually bring cases or to try to seek remedies domestically. They might have greater respect for human rights or more due process, and so there will be a sliding scale of what meets the threshold based on where you are, right? And what that means is with countries like Canada, where ostensibly there is such a strong kind of legal culture where there are these supposedly impartial, independent systems and processes in place, it makes it actually a lot harder because the threshold for exhausting those avenues becomes a lot harder to accomplish to then be able to bring a case on the international scene. So when it comes to exhaustion of local remedies, one thing that I think is really important to keep in mind is that the timing, how long it takes to exhaust a local remedy, can be one of the indicators of actually not having substantive or effective access to justice. And this is something, these are arguments that have been used in other contexts, because actually almost every country in the world has their own legal system, has their own legal processes, and there is an element of respecting that each legal system has their own way of doing it, right? And so people will try to bring cases locally, and there will be investigations, or there will be an open case or an ongoing case, right? Because there will be different ways that countries will deal with it. But if a case takes 10 years for someone to investigate, or if you're going through a process and there's actually no movement or nothing's happening, you're getting no response, you're not getting communication by the authorities, then these are all indicators that actually, whether in theory you have access to a remedy, in practice you clearly do not have access, because it shouldn't be taking this long. And these are ways that you can make an argument when you're bringing a case internationally that actually there is no real effective remedy here, or there's no access here, because you can't be expected to wait 10 years for an outcome. And there is jurisprudence from these committees where they have determined that, I don't know off the top of my head, but like 6 years is too long to wait for something like this. So yes, there's certain guidance based on the previous cases that have been brought where the Human Rights Committee, as an example, has said this is enough for us to determine that you've tried your best and you don't have access to a remedy locally, and therefore we're willing to evaluate your case. So that's the kind of the exhaustion of local remedies piece. The other piece that I just want to very briefly address is you brought up encampments specifically. So you brought up Canada specifically. Every single thing that I explained in my presentation today applies to Canada. Canada is not exceptional in any way. Canada is involved in human rights abuses locally against people here, against Indigenous communities here. As was mentioned, one of the projects that I worked on, the work that I did a few years ago, was actually working on the legal analysis of genocide for the National Inquiry for Missing and Murdered Indigenous Women and Girls. And what we determined was that Canada not only committed a genocide against Indigenous people, but that was an ongoing genocide, right? So Canada does not have his hands clean. And so everything that I mentioned is something that is applicable to Canada, including the UN human rights system, right? And including on issues that you've brought up. So, for example, the issue of encampments brings up a lot of different human rights that might not necessarily fall into the international crimes category, because genocide, crimes against humanity, war crimes, these are very specific legal terms, and they have very specific definitions. However, they're within a broader category of human rights, and what you brought up are specific human rights, like housing rights are human rights, poverty rights, the way poverty is treated and criminalized or how that's treated is a human rights issue, health rights. There's a lot of other rights that are applicable to that situation, and there are, for example, special rapporteurs that are specifically focused on these issues and that have come to Canada and made country visits and have talked about a lot of these issues based on what they have seen in our criminal justice system, in our incarceration, and when it comes to this. So this is also another way to engage, where it's not necessarily a court process or a legal process, but to make a submission to one of the UN Special Rapporteurs and ask them to actually engage with Canada, ask questions, send an official communication, put out a press release. These are also other ways of engaging the international system. And one thing that I will say, as an international lawyer that is rooted in Canada that works here, is that there are a lot of domestic human rights mechanisms here that people avail themselves, and there's a lot of human rights work that is being done on a national level, but it's not always in communication with the international level. And like the Constitution and the Charter is a really good example where we have a very robust human rights system here, including constitutional and charter rights that are meant to protect people. And so there are a lot of interesting legal challenges in courts right now based on that, but they're not always incorporating Canada's international legal obligations in the way that they frame these things. And that's a way where there can be a better dialogue between what international law says and what domestic law says. I know it got a little bit technical for the non-lawyers, but I hope that was helpful. Yes.
Hello, thanks so much for this insightful comment. I have a question. So many people here are, as far as I know, the victims of persecution. There are people from Islam community from Turkey, Tigray, Hazara in this room. And yes, there is this legal aspect of things that we, like some legal professionals, are very interested in and invested in. But for those who are not in the legal field, they want to do something as well. Like, what would you recommend? Like, I think you said you were part of like CCIJ. So like maybe you've been interacting with lots of victim communities. What things they have been doing right to get to the point where they could hold the perpetrators to account? And what would your advice be to the crowd here, including myself, about the next steps? Thank you.
Thank you so much for that question. It is a question that I get asked a lot, and I think it's a very complex one, because I think that we have to recognize that when it comes to legal accountability, you need a lawyer, you need a certain type of skill set and ability to address that, which is why I ended my presentation saying, you know, there are actual nonprofit organizations, community lawyers, you know, organizations like you mentioned, right? That's what I do as well. We're lawyers that we want to avail ourselves to communities, to put our skills to use to help engage with communities and build these strategies together to support them, because it's really hard to seek legal accountability without the legal skill set, right? So it's not something that any person can just come and do. And to have the highest chance of success, it's really important to connect with people who understand these legal systems and that can actually help. However, it doesn't mean that there aren't other things that individuals can do and victim communities can do. And I think there's a lot of different ways, but I think I'll focus my answer on one specific thing that maybe is underrated, and that's the power of diaspora communities who are outside of conflict zones, outside of the countries where a lot of these human rights are happening. When you are in another country, when you're a citizen or a resident of a country like Canada, you have access to a government here, and your voice should matter to them. You're their constituents. And so I think one thing that is important to keep in mind is that, you know, the Canadian government has a responsibility under a lot of these treaties to uphold human rights here, but also to engage with other countries through a human rights lens and to encourage other countries through diplomacy to respect human rights, but also to engage with their own allies or countries that they have economic relationships with or trade relationships with or other types of relationships with, to make sure that they infuse all of those relationships with human rights. And so I think one of the biggest forms of advocacy that would be really helpful and relevant here to communities that live in Canada is how to advocate vis-a-vis the Canadian government to make them hear your interests and what you think is important, so that when they are on the international stage, they will act in those best interests as well. I gave you the example of the International Court of Justice. You know, the fact that Canada is willing to bring a case against Afghanistan, it's not because Canada is a very benevolent country. There were so many civil society groups, Afghan community members in Canada that have been lobbying, that have been advocating, that have been raising awareness for years about gender persecution, about what's happening in Afghanistan. And they say, we are Canadians, we live here, we are the people that vote for you. We want you to take a stand because this is something that you say you care about. Canada has a feminist foreign policy. If you care about this, show us how you care about it. Don't just talk about it, walk the walk, right? And so these are ways in which diaspora communities and victim communities here in Canada can actually engage with their own government to make sure that their government isn't supporting countries and their human rights abuses, isn't providing money, weapons, arms, or other types of support to countries that are committing human rights abuses, and that they're actually actively advocating for countries to stop those abuses. And I think that's a really important power that diaspora communities have when they're in countries where there is a governance there, where there is actually an opportunity for your government to listen to you and to care about what matters to you.
Given that we have less than 5 minutes before the end of our session, and on behalf of our audience today, thank you, Amanda, for joining us. And thank you for being As we mentioned earlier, if any other questions, inquiries, or feedback, her website is on the screen, so please feel free to connect, and please do not forget to leave us a feedback as well. Thank you.
Thank you very much. I really appreciate all of you being here. 3 hours is a lot, and to hear my own voice, I'm already tired of myself, so I'm really grateful that you spent 3 hours really engaging with me. And like I said, this is my website, and so through my website, you can actually email me. There's a form there. If you have any additional questions, anything else that maybe wasn't clear today, or if you have follow-up, if you really want to learn more about this, I'm more than happy to connect with each of you and to actually follow up on any questions you might have. Thank you very much for your time.